there. My name is Christine Jerusik, and I am a partner at Richards and Jerusik Immigration Law. And today we're going to talk a little bit about deemed rehabilitation for entry to Canada and what that is. If you have committed an offense outside of Canada that, if it happened in Canada, would be on their criminal code, then you are inadmissible to Canada. And that means very much that you are not going to be able to go to Canada to visit, work, fishing trips, hunting trips, anything you need to do if you have this conviction on your record. And so the question becomes, how do we overcome that conviction? And there is a way to overcome it automatically without doing anything at all. In a specific set of circumstances, the Canadian government has said that they will automatically forgive people for past offenses. And that is what deemed rehabilitation is. So deemed rehabilitation is by operation of law, and it is something that happens automatically. Individual rehabilitation is where you have to make an application to go to Canada, either a rehabilitation application or an application for a temporary resident permit. There has to be some proactive action taken on your part to do that. But deemed rehabilitation just should happen by operation of law and should overcome your inadmissibility in certain circumstances. The most important thing in determining whether you can be deemed rehabilitated for your offense is to know whether your offense is considered major or minor under Canadian law. And that determination can be difficult to make. You actually have to compare your offense and the number. You got to read the law of the state that you offended, or the federal law that your offense is classified under, and then compare that to the Canadian immigration law or Canadian criminal law, pardon me. And so that kind of an evaluation should really be done by an attorney that is qualified both in the United States and Canada. They're the people that are going to be qualified to help you with that. Immigration consultants in Canada typically aren't qualified. They don't have any U.S. Legal training. Similarly, Canadian attorneys that are only practicing in Canada and don't have any qualifications in the United States are also not great at this. They don't have any U.S. immigration training or criminal training either. So very, very niche practice area, and you should really be looking for an attorney that has both qualifications in order to represent you properly in this and make that correct determination for you, because your offense might be considered minor and you should be deemed rehabilitated if that is the case. So who is eligible for deemed rehabilitation? I talk to people all the time and they want to know if they have to do anything to go to Canada. Maybe they've got something coming up, or just future plans are going to take them to Canada, and they want to make sure that they're able to go. So in order to be eligible for deemed rehabilitation, that you need to have, your conviction needs to be just one, okay? So you can't have more than one. If you have more than one conviction, in most cases, you are not going to be eligible for deemed rehabilitation. You would need to look at individual rehabilitation and make an application for that. Similarly, the passage of time is very important. So if you look at the equivalency between your offense and the Canadian offense, and there's a determination that, hey, this is a minor conviction, then we want to look at the passage of time. Has 10 years passed since the completion of your sentence? And the completion of the sentence is a specific moment in time that happens when everything is done. So if you had probation, that would be the end of your probation. If you had a license suspension, perhaps as part of your DUI offense, the return of that license sometimes is the last piece of the puzzle. But everything needs to have happened: fines paid, classes attended, driver's license returned, probation completed, in order for that 10-year clock to start running. And then you need to have no other convictions in the intervening period. So like I said, more than one conviction is not gonna, deemed rehabilitation is most likely not gonna apply to you. And just so you keep in mind, deemed rehabilitation is automatic. There's no application to make. So you wanna just make sure that you're not traveling before that 10-year period is up. And then once that 10-year period is up, you're able to go to Canada and you shouldn't have any issues at the border. There are limitations and exclusions on when deemed rehabilitation applies. So it certainly doesn't apply to any offenses involving serious criminality. So Serious criminality in Canada is determined by the sentence that they would give for the crime if it happened in Canada. And if that sentence is going to be for a period of time of 10 years or more, if they're able to give that type of a serious sentence, then that is considered serious criminality. And so people who have an offense or a conviction for something that is serious criminality are not going to be eligible for deemed rehabilitation. They're going to want to look at the individual rehabilitation or temporary resident permit as an option for them. Just so you know, DUI offenses post December 18th, 2018 are likely going to be considered major criminality. They're going to be serious. They're not going to be something that's minor and eligible for deemed rehabilitation. DUI offenses that are committed prior to that date, prior to 2018, those people are grandfathered into that old law because they did change the law in Canada in 2018. They're grandfathered into the old rule, and that means that their offenses could be, in certain circumstances, considered non-serious criminality in Canada and therefore eligible for deemed rehabilitation if they only have one. Again, multiple offenses. You do not qualify for deemed rehabilitation if you have multiple offenses. Similarly, if your DUI is older, but there was some complicating factors, there was a bodily injury or property damage involved in that, it may also be serious criminality. So you want to consult with a attorney to make sure that you can go without issue. Now, what happens at the border when you're deemed rehabilitated? Maybe you've talked to an immigration lawyer, or you've made an assessment on your own that your offense is minor. You counted the time from the end of your sentence, and it's been more than 10 years. You should be able to travel to Canada. And if you are confronted at the border with questions about your offense, answer honestly, and the officer should be able to make a determination that you're deemed rehabilitated. Typically, when I talk to people, I encourage them to bring proof of that with them, because the border officers, they don't have access to your full criminal records, all the judgments from the court and all of that stuff. They just see a simple background check results. So you want to make sure you have with you important documentation for that border interview, including possibly your court documents, your proof that you completed your sentence and when that happened, showing that it was over 10 years ago. I often encourage people to bring their FBI report or get a copy of that, because that's going to show them, their full criminal history. And then sometimes with the DUI, it's important to bring that DMV driver record to show when you got your license back, because that was the last thing that happened and the last piece of your sentence that was completed. So with those documentations and with confidence that you have something that's a non-serious criminality, you have only one offense, and it's been more than 10 years of the completion of your sentence, you should be able to travel to Canada. And even if you are questioned at the border, present those documents, share that information, and the officer should be able to make a determination that you are deemed rehabilitated. Who should seek help with this? Now, if you don't know if your offense is serious or non-serious in Canada and you want somebody to do an equivalency for you, that would be a good time to seek, legal assistance with that. So if you don't know if your offense is minor, let's find out. Let's talk and figure that out. Where deemed rehabilitation doesn't apply to you, so you've figured out, okay, this is a serious criminality, or I have more than one conviction on my record, then I know I'm not deemed rehabilitated. Again, it's going to be important for you to seek assistance with that so that you can make an application for individual rehabilitation. So I encourage you to have a consultation to determine those things, help you figure out whether you're deemed rehabilitated. I talk to many people all the time who have questions about this or think they can't go to Canada, and we happily figure out that they can and that they're deemed rehabilitated, and there's nothing they really need to do other than take their documents with you to the border. So I encourage you to reach out if you need assistance with that. Deemed rehabilitation, keep in mind, just to summarize, is an automatic rehabilitation. Nothing you need to do, nothing you need to apply for, but you do need to make a proper determination as to whether it applies to you before you travel, just to avoid any issues. I invite you to subscribe for more immigration updates. Contact our office if you need any legal assistance with these matters.